Hello, and thank you for joining Mayer Brown's Global Financial Markets teleconference series. Today's call is entitled The Expected and Unexpected Impact of Recent Russian-Related Sanctions on the Loans Market. Today, we aim to provide a high-level overview of the latest Russian sanctions and export controls, something that won't be easy given they continue to be updated on almost a daily basis, and then to run through some issues that we're seeing in loan transactions. My name is McDermott and I'm a partner in Mayer Brown's London office. My practice involves cross-border loan financings in emerging markets, and I previously worked in Hong Kong and Moscow. Before going further, I want to say that everyone at Mayer Brown is saddened to see what is going on in Ukraine and praying for a peaceful resolution as quickly as possible. As regular listeners will know, this call is being recorded. We will be emailing an audio link to all participants should you wish to listen to the teleconference again or forward it to your colleagues. In addition, the recording will also be available as a podcast on your preferred podcast platform. Since we will not be having a Q&A session, please send any questions regarding today's topic by email to gfm@mayerbrown.com and we will respond promptly. This is the same email address on your invitation. Joining me today are Mayer Brown partners Jason Hungerford and David Duffee. Jason is a US and UK qualified investigations and regulatory partner in the global trade group of our London office. Previously based in Washington, D.C., Jason advises corporates and financial institutions on economic sanctions and export controls, anti-corruption and anti-money laundering. David is a partner in our New York office and is the leader of our New York banking and finance practice. He advises financial institutions and borrowers in lending transactions, both for US-based borrowers and in cross-border financings. And a significant part of his focus is on Latin American lending. With that brief introduction, we'll now begin today's discussion. So, Jason, over to you.
Great. Thanks, Ash. I'm sure all of you who are listening today have watched with interest and emotion the events of the past fortnight. For those of you who trade with Russia, this has been a period of seismic legal change with new measures announced and implemented on a daily basis, and sometimes even more frequently than that. The business impact on many industries has been immediate. There's been extraordinary coordination, as you've seen, between many of the sanctioning authorities, in particular the EU and the US and the UK. But due to differences in their legal systems, their established practices of imposing restrictive measures and to some extent underlying policy positions, what we have now is an array of overlapping measures. Taken together, they represent the most restrictive package of sanctions ever imposed, short of the complete embargoes imposed by the United States on a small number of countries, but certainly it's the most restrictive sanctions program targeting one of the world's major economies. Also, due to some delayed implementation and general licenses, there are different starting lines, I suppose, in how quickly financial institutions and corporates need to comply with their provisions. And they're also subject to further change. I mean, just yesterday, 8th of March, the United States and the United Kingdom announced import bans on Russian oil. And late last week, the EU discussed behind closed doors another dozen or so potential sanctions measures for use should the situation in Ukraine not improve or worsen. So where are we today? I'll run through a number of the measures that are in effect now, as or will come into effect in the next few weeks. As you'll appreciate, this is a rapidly changing situation, but the contours of the restrictions are mostly familiar to us. So as we all know, the kind of initial measures that were imposed were to extend the trade embargo, or for the EU, so somewhat less restrictive than the US, trade embargo on Crimea to the Donetsk and Luhansk regions as well. Sanctioning authorities added many more individuals to their assets freeze and blocking sanctions lists, mostly with military or finance sector connections. Second stage was that comprehensive sanctions were imposed on certain Russian banks, most notably VTB Bank, as well as the entities they own or control. The Sberbank, the largest Russian bank, was set up to be excluded from the U.S. and U.K. financial systems via a prohibition on correspondent banking that's set to come into effect in the next few weeks. The EU prohibited SWIFT from providing messaging services to 7 banks and their subsidiaries. And last week, amongst those discussions with the EU, was the possibility that all Russian banks would be cut off from SWIFT as well. There were many more entities in all 3 of those jurisdictions made subject to restrictions on dealing with debt and equity. These are those so-called sectoral sanctions that came into effect for the first time in 2014 when Russia purported to annex Crimea. These restrictions have now been expanded to a greater number of Russian entities. There are bans on dealing with the Russian Central Bank, its wealth fund, and the Ministry of Finance, the Russian Direct Investment Fund, and in the U.S. and then overseas in the EU to dealing in the debt of those entities. A great expansion of export control restrictions, covering not only really any dual-use item for use in Russia or export to Russia, but also an expansion of restrictions in the EU to cover certain items and technology related to aviation and oil refining and space. There are now restrictions on deposits from Russian nationals and residents, and soon certain securities depositories, central securities depositories, will be prohibited from dealing in securities for Russian nationals and residents, or selling euro-denominated securities or shares in the funds that contain them. And in addition to that, there are restrictions on overflight of Russian aircraft, entry of Russian ships into certain ports, travel bans, prohibition on the sale of banknotes, and restriction on Russian broadcasting. As I said at the beginning, this is a broad swathe of sanctions, everything sort of short, I should say, of a complete embargo. A couple of comments, perhaps to put this in context, however. I mean, the first is that this isn't an embargo. It is not generally prohibited to deal with Russia, but it may soon seem so if it already doesn't in some sectors. So over the past week, I've seen the types of questions that I receive begin to move from how do these new laws affect our business with Russia to how do we get out of Russia. I had a call earlier this week with an FMCG client who said that they'll continue to sell their food and medicines products in Russia, but they're fretting about how they will get parts and spares for their manufacturing lines and how those will be viewed in the public sphere, even if they can be exported under the current export restrictions. And we've seen sort of perhaps less quote unquote essential consumer goods companies pull out of Russia just in the last few days. I think overnight it was Coca-Cola and Starbucks, etc. A second comment is that these current sanctions make it more important than ever to have confidence in your counterparties. Given that sanctions could continue to be increased and likely will be increased in the near term, it's worth being particularly vigilant. So on Monday morning, I gave a presentation to the debt capital markets team of a European bank, and I said this to them. I said that we've emerged from a relatively static period in sanctions regulations, and there's always something changing. But for some time, we've been saying, don't deal with these 5 countries: Cuba, Iran, Syria, Crimea, North Korea, and then screen your counterparties and their beneficial owners against lists of assets freeze targets, and that's kind of enough. There's been some concern over Russia and Venezuela, and sometimes those countries find their way into provisions, but really that only affects certain sectors and well, with respect to Venezuela, the government. Now, though, I mean, it's more important than ever, I told them, to be confident that your issuers understand sanctions and are able to comply with them in the course of their day-to-day business, because and also what their position is, on Russia generally. Many of them are pulling out due to the legal uncertainty inherent in dealing with Russia now, but also reputation, moral objection, or some combination of the three. And so that, in the context of that conversation with that team, meant know your issuer and whether they are able to comply, because those who are staying in Russia are now going to be under heightened scrutiny by enforcement agencies, and probably ought to be under heightened scrutiny by the financial institutions that service them. I mean, so Ash, I mean, I'd be interested in hearing how the sanctions then, maybe some in the context of what I've said, are affecting the syndicated loans market in Europe.
Thank you, Jason. That's a very helpful summary of where we are currently, and as you say, things are changing on almost a daily basis. We don't have time today to run through every possible scenario that might arise as a result of those sanctions in the lending space, but we are assisting clients with lots of similar questions, and we'll try to cover some of the most common. Before we do that, I want to stress that it is very important when considering the impact of sanctions on your existing deals to look into the specifics of the rules, which Jason has summarized. And there are three key questions in this respect. Firstly, does my institution need to comply with EU, UK, US, and or any other sanctions regimes? And for many international organizations, there will be a lowest common denominator approach and a desire to follow all such sanctions, which is understandable given the size of historic fines for breach of sanctions, which are well documented. But you may not have the rights under the finance documents to do that where you're not legally required to do so, meaning that taking an overly cautious approach to sanctions could expose yourself to future claims for breach of contract. The second question is, what do the sanctions rules we need to follow say, and is there a general license which allows us to take certain actions, even if they would otherwise be contrary to those sanctions? And as Jason has outlined, there are different levels of sanctions applied to different entities and individuals. And for example, Sberbank is a sanctioned entity in the UK and the US in relation to maintaining correspondent banking relationships, as Jason said, and also prohibitions on new debt issuance of more than 14 days or equity. But Sberbank is not yet on OFAC's SDN list, meaning it's not subject to as severe sanctions as, for example, VEB or VTB to other Russian banks. So you really need to drill into the detail of the exact entities that you're dealing with and get sanctions advice. As Jason mentioned, there are also general licenses issued by, in the UK, the OFSI and OFAC in the US, permitting things like the official business of various multilateral development banks and transactions which are necessary for the winding down of existing derivative transactions, at least for the next month or so. So again, you really need to get specific and seek advice before making decisions on what you are permitted or required to do or not to do, as the case may be. The third question is, what does my contract or loan agreement say about my rights and obligations? And of course, this is important because, as I mentioned, the terms of the contract may, in some cases, be somewhat at odds with what you're permitted to do or required to do under applicable sanctions laws. And this goes beyond looking merely at the sanctions-related clauses, as we'll see in some of the scenarios. Okay, so bearing in mind those three initial key questions, what sorts of issues have we seen in the loans market with respect to sanctions? The first scenario is where obligors are subject to sanctions. In some ways, this is the easiest scenario to deal with because it's likely that your loan agreement will have provisions dealing with it. And once you've identified the legal position and the contractual position, these circumstances will likely mean that there's an event of default or a mandatory prepayment event. It is, of course, prudent to assess at this point whether the agent and ultimately the lenders are permitted under the sanctions rules to receive amounts owed by a sanctioned party. which will be a fact-specific analysis. It may even prove to be academic if the Russian borrower is unable or unwilling to pay those amounts. And we've already seen presidential decrees in Russia limiting the ability of Russian individuals to convert or transfer hard currency funds abroad, and we might see more similar rules as the days go on. The second scenario is where there is a lender in the syndicate that is subject to sanctions. And given that many of the sanctions have been aimed at Russian financial institutions and their European subsidiaries, there are deals where the borrower may have nothing to do with Russia or Ukraine, but where these new sanctions are still relevant because there are Russian or Russian-owned or controlled lenders in the deal. This is particularly the case in the structured trade and commodity finance space, for example, where European subsidiaries of Russian banks have become quite active in recent years. Agents and borrowers have been asking us whether they're still able to pay amounts to or receive amounts from those lenders. And again, a careful fact-specific analysis is required here based on the specific transaction sanctions rules themselves, as well as the terms of the finance documents. Usually an agent can rely on the general agency wording in a loan agreement, which makes clear that it is not obliged to do anything if it would or might, in the agent's reasonable opinion, constitute a breach of any law or regulation. However, we have heard of examples where an agent bank's internal compliance teams have, in an abundance of caution, prevented payments which were due to certain lenders in the past couple of weeks, where those lenders were not in fact subject to sanctions yet, meaning that the agent may then be in breach of contract. Where applicable sanctions do prevent a payment to or from a lender in the deal, agency teams are likely to hold such amounts in holding accounts until the sanctions rules permit them to make the payment. Indeed, this has happened previously in relation to Iranian and other sanctions. From a borrower perspective, the payment mechanics clause in most English law loan agreements will state that it has extinguished its obligation to pay once it has paid the agent. So the fact that the agent cannot pay the relevant lender its pro rata portion should not result in a non-payment event of default. Another question is whether a borrower or agent can somehow eject the Russian lender from the deal. Now, there might be an illegality mandatory prepayment event, but that usually needs the affected lender to request to be prepaid and cancelled. The LMA's defaulting lender concept, if present in your deal, might also help, especially if the lender has entered into some form of bail-in regime under the European Bank Recovery and Resolution Directive, or BRRD, or other similar regimes in other jurisdictions. And that was the case for Sberbank Europe AG in Austria, and will also presumably be the case for other subsidiaries of other Russian banks in the near future. Now, although being a defaulting lender may only disenfranchise that lender and mean it isn't entitled to commitment fees, it may still be worth looking into. Otherwise, the best course of action is not immediately apparent in this circumstance. Even if a borrower wants to prepay loans and cancel available commitments of an affected lender, it would likely need the consent of all other lenders to do that, given that cancellations and prepayments usually can only be made on a pro rata basis. And then there is also the question, of course, of whether those payments can actually be made in accordance with applicable sanctions rules. Another area where we're seeing lots of questions relates to trade finance more broadly. We've been assisting various clients, in particular in relation to letters of credit and other documentary credits. It's a fundamental principle that issuing banks should make a determination of whether or not they pay a beneficiary of an LC based solely on the face of the documents presented to them, without regard to the underlying transaction. A letter of credit, once issued, should be irrevocable. And as far back as 2014, the ICC released a guidance paper on the use of sanctions clauses in trade finance-related instruments. That paper largely advocated against the use of sanctions carve-outs due to the uncertainty they create. However, compliance teams have required some banks to include such provisions, allowing them to refuse to pay out to a beneficiary if it would be contrary to sanctions to do so. The difficulty we're now seeing is that many trade finance instruments are of a back-to-back nature, with issuing banks, confirming banks, advising banks, discounting banks, all sometimes being involved in the same structure. And the position with regard to sanctions is not always uniform across the documents agreed between all of the parties. If there are any documents at all, in some cases such structures are sort of governed by SWIFT messages and standard form terms. And this means that some banks in the chain are left in a position where they are obliged to pay out because their documents don't contain sanctions carve-outs, whereas others are able to rely on those carve-outs. This is one example of how the recent Russian sanctions have unexpected consequences, even in documents and deals where there is no immediately apparent connection to Russia, given how integrated the Russian economy was in the global financial markets. More broadly, there are, of course, general issues, not specifically relating to sanctions, but linked to the events in Russia and Ukraine. A detailed analysis of these is probably beyond the scope of this session, but it's wise for lenders to be mindful of possible knock-on impacts of all of this on their borrowers, and to consider whether covenant resets may be required, for example, global businesses who've been forced to close in Russia or Ukraine, as Jason referred to, or maybe they can't access goods or services that they previously used to from those areas. Businesses may also require additional liquidity to be able to meet rising commodity and energy prices. And in extreme cases, force majeure clauses or material adverse effect or material adverse change concepts may even have occurred for those businesses which are heavily impacted by the macroeconomic climate. In this sense, it might be a good idea to dust off your notes from when COVID first hit a couple of years ago, as similar principles and clauses are relevant here, albeit for very different reasons. And finally, there is the practical aspect of what we're seeing at the moment. Jason touched on the additional focus from a compliance perspective more generally, and I think people working in financial institutions can expect a lot more focus on KYC, know your customer, and know your customer's customer, KYCC. And also there is a heightened focus on things like delivery of notices. If you need to deliver a notice to a counterparty, we've seen difficulties with delivering notices to counterparties in Russia at the moment, given that various international advisory firms are closing offices in the country. And with that, I'll pass on to David. David, these are just some of the questions we've been seeing here in the European loans market. How are the events in Russia and Ukraine and the resulting sanctions having an impact in the loans market in the US?
Well, thank you, Ash. Let me talk a little bit about the U.S. market and how, in the loan space, it's been affected by the war and by the changing sanctions regime. And it's fair to say that transactions involving Russia or Ukraine are less common in the United States than they are in the UK and the rest of Europe. But there are transactions in which these issues come up. And it's important since an institution, either a financial institution or a borrower's strategy or analysis of the problem may be led from Europe, because that's where most of the transactions are centered. It's important to keep in mind that English law is not always the same as U.S. law, and you shouldn't make assumptions about how U.S. law exposure is going to treat a situation based on your analysis of how English law is going to treat that particular issue. I'm going to talk about two different scenarios. One is where we have a borrower who is not itself sanctioned, is not Russian, but is adversely or likely to be materially adversely affected either by the war or by the sanctions regime. And then second, I'll talk about a borrower that is actually a sanctioned entity. So first of all, and probably the situation that's most likely to exist in the United States, is a situation where we have a borrower who has exposure to Russia or Ukraine, and it is going to have, and the war and the sanctions are going to have an adverse effect on its financial performance. U.S. documentation, or at least typical U.S. syndicated loan documentation, is not likely to have an event of default focused either on war or on the imposition of a sanctions regime that adversely affects the borrower. That means that there's likely no immediate remedy for a creditor as a result of anything that's going on in Ukraine. Ultimately, we assume there may be a failure to meet a financial ratio or other financial tests because the company's financial performance has been adversely affected, but no immediate event of default. However, and probably the bigger issue for lenders in a U.S. law-governed document is whether they would be obligated to make new extensions of credit to this borrower who's adversely affected by the war and by the sanctions. And we don't, in U.S. documentation, typically have a standalone material adverse change event of default, but what we do typically have in the United States is a requirement that at the time of each drawdown, there be a re-representation or a repetition of the representations that were made immediately. And it is possible that one of those representations is no material adverse change in financial condition. And if a lender can take the position or is able to argue that the war or the sanctions have had an adverse financial impact on the borrower, they may be relieved of their obligation to lend. That, however, is something that lenders are, at least in the United States, are reluctant to do because that language is very general. And even if the lender is confident that the sanctions regime, the war is going to, have, an extremely negative effect on the company and may adversely affect its ability to repay the debt when due, that doesn't necessarily give the lender enough comfort that it can stop lending to that borrower who's affected by the war and the sanctions regime. There may be a different result under English law documents, but that's probably the result under U.S. law documents. For lenders, that means they need to scrutinize their documentation to see if there's some basis on which they can be relieved of their obligation to lend, either in the text of the MAE definition itself or other provisions in the loan agreement. It also, of course, is a facts and circumstances analysis, and it may be in a particular case that the repercussions of the war and the sanctions regime are so onerous that a lender feels comfortable not lending. For borrowers, of course, their analysis has to be, whether a borrower should draw down its revolver right now to have access to liquidity before they are clearly forbidden from borrowing because a financial ratio has been tripped. So those are some of the issues that people are thinking about now for borrowers that are adversely affected by events in Russia and the Ukraine. For new deals, we have seen some talk about amending or revising MAE definitions to specifically reflect the situation, the sanctions situation, the war. We have not, however, seen that, but we haven't seen that a lot in the loan context, and we actually haven't seen it at all in the syndicated loan context. We are seeing that in the U.S. in the M&A context, where MAE definitions are a lot more detailed and subject to a lot more negotiation, and it will be interesting to see if some of that architecture of changes in MAE provisions makes its way from the M&A market to the loan market. So that was a discussion about a borrower who's adversely affected by sanctions. Maybe we'll talk briefly about a situation in which we actually have a borrower who is subject to sanctions. Again, that probably is not, a entity that was once not sanctioned, becoming sanctioned, is probably not in and of itself an event of default under typical U.S. loan documentation. However, meaning that a lender can't accelerate. However, it probably is a misrepresentation, and if the representation needs to be repeated at the time of a drawdown, which is typical, a borrower won't be able to repeat that representation, giving the lender sort of a clear ability to be relieved from its contractual obligation to lend. Of course, probably more important than a lender's contractual obligation to lend is its obligations under applicable legal regime in the U.S., or UK, or Europe, not to extend credit to a sanctioned person. And of course, even if your documentation is ambiguous or doesn't give you the right to be relieved of your obligation to lend, applicable law may say you cannot lend. And I think this is an appropriate point for me to make an obvious statement, but one that I think needs to be made, and it follows from what both Jason and Ash were saying. We see lenders in the United States focus an enormous amount of energy on their contractual provisions regarding sanctions. And of course, as a lawyer, I think that's a wonderful thing. But none of those contractual provisions are going to save a regulated entity or an entity that's subject to compliance with sanctions from an enforcement action. The fact that you got a beautiful representation or a beautiful covenant doesn't mean anything to a government that is enforcing sanctions. And what is important is that the lender conduct its due diligence to make sure that its credit does not involve, its extending credit to a borrower does not involve any violation of applicable sanctions. One thing that I think is going to be interesting to watch in the syndicated loan market is a situation where, I don't know that this has happened yet, and I don't know that it will happen, but let's say we have a borrower that is prohibited under applicable Russian law from making payments to a U.S. bank or a U.K. bank because of actions by the U.S. government or the U.K. government or the EU for that matter. We may have a situation where that Russian borrower will decide to make payments directly to banks that it's permitted to make payments to, banks in jurisdictions that have not taken actions against Russia, and not have those payments go through the agent. And in U.S. documentation, that would almost always trigger in a syndicated loan agreement a sharing provision so that a U.S. bank or a British bank could go to the bank that received the payment and say, share that payment with us pursuant to this sharing provision. That happened before during the Falkland Islands War when Argentina did that with some of its syndicated credit facilities. And in that situation, the British banks that did not receive payments from Argentina attempted to invoke the sharing clause and were ignored by the other banks in the world. It'll be interesting to see if that happens again this time. And then finally, just to say real briefly, of course, the bigger issues, or some of the bigger issues that Ash talked about a lot, were a situation in which we have a syndicated loan and either the agent or one of the lenders in the facility is itself a sanctioned entity, and that has a lot of potential implications under the credit documentation. Again, that's a scenario more likely to arise in Europe than it is in the United States, and it will be interesting to watch how lenders and borrowers make their way through those issues. That's what we're seeing in the United States. Ash, I'm going to hand it back to you.
Thank you, David. Very interesting indeed. And thank you to our audience for tuning in today. A couple of brief reminders. You will receive an email with a link to today's recording, and the recording will also be available as a podcast on your preferred podcast platform. And if you have any questions related to what you've heard today, then please do email them to gfm@mayorbrown.com. Thank you again for your participation, and you may now disconnect.